That boy is zoomed in. What's up? Grandest of risings to all. I'm so happy to have y'all here this morning. Grand rising. I hope y'all are doing well. Yeah, man. What's up, y'all? Why is it so? Okay, I guess that's normal. Grandest of risings to all of you beautiful people out there in the world. Oh, I love all of y'all. Y'all are the most amazing, most compassionate. I love all of y'all. Grandest risings. Welcome to another episode of the Handbook of Common Law Pleading. This is going to be part two. Part two. We in this thing. You know what I'm talking about? You dig? Yeah, man. Hope you're understanding today is a blessing. This moment of now. Everything is now. There is no past. There is no future. There is only now, as now has always existed. Time is an illusion. Once you get to that realization, your life starts to change. Be the change in the world. Adapt to the change. Expect it. Adapt to it. Like my boy Bob always says. What I wanted to do real quick is let y'all know. You can, I don't know if y'all know about this. Some know, some don't. But you can get everything that comes from Power Inherent in the People and Operation Wise Dome directly at www. I'm going to put it in the chat for y'all. https www.bio.site/CJW. Okay, we'll go ahead and pin this for everybody as well. Pin message. So it'll be at the top of the chat. I got the chat rolling now so I can see what's going on. And again, you can get everything. So what I just did is I dropped for Operation Wise Dome members. It's free. Of course, all production as far as or development, curriculums, books, courses, all Wise Dome meetings is of course free directly to Operation Wise Dome members. But we just dropped an asserting sovereignty criminal defense curriculum, and you can get that right now. It's for $19. This is an amazing one. Okay, this is an amazing one. It's a criminal procedure, rights, and constitutional protections. Again, asserting sovereignty. It's a Wise Dome criminal defense curriculum, and you can get that right now. We just dropped that yesterday, day before, directly at again bio.site/CJW. Of course, you can join Operation Wise Dome. If you need to book an appointment with me, the link is here to get the Self-Governing Bruh book. Okay, the Self-Governing Bruh book right here, as you see in my hands. You can get that as well. Okay, and then the YouTube channel, which you're already on. If you need to join the Discord server, okay, if you want to join the Discord server, the link is on there as well. We got 953 members now, y'all. 953 members in the Discord alone. The BJW, Brandon Joe Williams, plus Cameron James Wilson, Drive versus Travel, PDF. The Last Tread, the audio book. Now, you can actually get the PDF and audio book for free. If you go to PIITP.com, okay, and you sign up on the update, you go to update, and you sign in or submit for the mailing list, you actually get this for free. You can actually get the PDF and the audio book for free, y'all. So just wanted to let y'all know about that. Quick little hack. You can also get the Sovereign and Citizen of the Land paper book, okay, on the site. It's right here in my hands, as you can see. It's a follow-up to Self-Governing Bruh. Then Rebut That Shit, which is going over the 12 presumptions of law and how to rebut those. The Right to Travel beginner course. The Advanced Right to Travel course. Now, if you get this Advanced Right to Travel course, you also get the Beginner Right to Travel course for free. We also have our traffic law reform petition. We need more signatures. We only got 2,000 right now. We need more signatures. And again, this is to reform the traffic laws as they are currently in place, as they are harming our citizens all throughout this nation. And I think it's something big that we need to change. We just got done working on developing Michigan. This is an update before we just get into everything, y'all. But we just got done developing Michigan's outlook, the bill, and all of the information that needs to be presented over. As you can see, we just did Michigan. What was this? March the 4th. So we've got Michigan in place now with the analysis, the conservative legislators to reach out to, the email outreach, the bill validation as far as laws and case laws is concerned, and then the actual bill in and of itself. So I stay working in the background very heavily. I hope y'all can understand that and know that. But again, the Michigan Right to Travel Act, a bill enacted, an act entitled an act to amend the Michigan Vehicle Code. Okay. So we stay working, no matter what y'all thinking. We out here working. Michigan was just developed on March the 4th. Wanted to update y'all on that. What else we got going on? The website PIITP donation. If any of y'all are able or eligible to give a donation for the cause and the mission and support everything that we're doing, I would say become an Operation Wisedome member so you can get all exclusive access to everything. But if you feel like you just have it available to give a donation, we greatly appreciate it. This is everything I do. I don't have a job other than working for the people. And then the notice of liability as well. This notice of liability is the highest form of protection when filed with any governmental agency. I can show you all a quick preview of that as we have updated it from what I have previously filed before in life. Notice of liability, where are we at? Notice of liability. And this has been updated, like I said, so it's more inclusive, right? Notice of liability, private fee schedule, coming in with everything. Notice of specific prohibitions, private fee schedule, terms and conditions, and then a verification with a notary as well. Okay. So you can get all of these things again directly at www.bio, that is bio.site, that's site/CJW. All right, so I hope everybody is doing very, very well this morning. This is part 2 of the Handbook of Common Law Pleading. Shout out to my boy Willie. Willie got this bad boy all printed out, sitting at home. He sent me some pictures yesterday, and I thought that was just amazing. It's good to see Willie. Hope you're blessed out there, my brother. Okay, so let's get into it. I need to scroll down where we leave off on. So yesterday we left off on this paragraph, and we're going to continue on. All right. Now, the relation of common law pleading to other systems. The nature and function of pleading at common law may be better understood when viewed in its relationship to other systems of procedure which developed prior to, contemporaneous with, or even subsequent to it, including equity and code pleading, as well as pleading under the new federal rules of civil procedure. In order to give a better perspective of the nature and function of common law pleading as a factor in Anglo-Saxon law, it may be well to consider its relation to other systems of procedure which developed prior to, contemporaneous with, or even subsequent to it. These include, again, the equity of code pleading, as well as the pleading under the new federal rules and the relationship of which pleading will now be considered. Now, the relationship to equity pleading. Equity pleading was the system of pleading which was developed by the courts of equity in England through the king's exercise of a portion of his judicial prerogative in cases involving matters of conscience. Okay? Involving matters of conscience. This is going to be important later on as we get into it, because again, we're pulling at the conscience of the court in relation to equity. The king's authority was in the beginning handled through its chancellor, who was a churchman trained in the canon or ecclesiastical law, which has its roots in the Roman law. Hence, it is not surprising to find that both systems failed to provide a jury for the trial of facts. As a result of this characteristic, certain differences between the common law and equity systems of procedure developed. Now, in the first place, at law, the pleadings at common law were required to reduce the controversy to a single clear-cut, well-defined issue of fact or of law, whereas in equity, there could be as many issues of law or of fact as the pleaders desired. This was due to the dual character of the common law court, which consisted of the judge, who normally decided questions of law and relation of pleading to other systems, and the jury, which decided questions of facts as opposed to the equity court, consisting of the chancellor only, who was a trained lawyer, capable of handling complicated issues of both law and fact. Secondly, and largely as a result of the first difference between two systems at law, a plaintiff, in order to state a cause of action, was required to state ultimate facts and not evidentiary facts or conclusions of law, whereas in equity, he might plead ultimate facts, evidentiary facts, and even conclusions of law, as the chancellor could unravel the issues in spite of the resulting confusion. Let me spark up, man. Let me spark up real quick, you dig? TMS 4945. TMS 4945. If you look in the description of this video, you will find the Discord link. Okay, my brother? Thirdly, at common law, only those parties who had an interest in the right being litigated could be joined as plaintiffs, and only those parties who were subject to a joint liability could be joined as defendants, whereas in equity, the procedure for the joinder of parties, plaintiff and defendant, was much more flexible. Fourthly, at common law, a party was frequently entitled to trial by jury as a matter of right, and if the jury returned a verdict in favor of such party, its findings on the facts was binding on the court, whereas in equity, a party was entitled to a trial by jury only in the discretion of the chancellor, and if, perchance, the jury found in favor of a party on the facts, such finding was not binding on the court, was only advisory in its effect, the chancellor being free to disregard it in his discretion. Very interesting. Very interesting. Fifthly, at common law, a judgment had to be rendered in favor of or against all the defendants. It could not be split so as to apportion the liability among the defendants, whereas in equity, the decree could be split up and given against one or all of the defendants, thus allowing for a much more flexible apportionment of liability without the necessity of further action. Sixthly, at common law, a judgment merely determined the matter of right between the parties. Listen. Sixthly, at common law, a judgment merely determined the matter of right between the parties. Between them two. No one else. It didn't go outside of that. It did not order the defendant to do anything. And if the defendant was not goaded into action by the mere moral suasion of the judgment, the plaintiff was compelled to sue out of execution on the judgment. Whereas in equity, the decree not only determined the matter of the right between the parties, but it actually ordered the defendant to do something in recognition of that established right on peril of being punished for contempt for failure to do so. Seventhly, at common law, only questions of law were ordinarily open to appellate review. If the error of law was apparent on the face of the record, it was reviewable by writ of error. If it was not apparent on the face of the record, but was one which occurred at the trial prior to the Statute of Westminster in 1285, the only method of review was after verdict and before judgment, by a motion for a new trial. But after the statute, such errors could be reached by a buffet of exemptions. Whereas in equity, both questions of law and questions of facts were reviewable on equitable appeal. With these distinctions between common law and equity procedure in mind, it becomes readily apparent that when the court of equity undertook to settle matters of conscience in dispute between private parties, influenced by civil law background of the chancellor, it naturally adopted the civil law mode of procedure, avoiding the technical rules of pleading as they existed at common law. So in theory, however, in equity, as at common law, the forensic altercations between the parties might be carried to an unlimited extent, thus permitting the plaintiff and defendant, through alternate allegations, to frame issues of law or of fact upon which the court could base a decree. So in framing his statement of cause of action in what was called bill in equity, as opposed to a declaration at law, the plaintiff followed no set form of action, as at common law, but proceeded upon a board of equities involved in the controversy and stated the facts at large, mingling both questions of fact and of law, there being no need to separate them on the record as at law, since there were both to be decided by the chancellor, who was trained in the art of sifting from the complicated statements the determinative issues, whereas at law, issues of fact were to be decided by a jury, while issues of law were to be passed on by the court, and both types of issues were framed by the parties, and not as in equity, extracted from the pleadings by the court. In practice, however, the pleadings in equity did not ordinarily go beyond the replication stage and frequently not beyond the answer. What really happened was that each party stated all the facts in one pleading, though properly belonging to a subsequent stage of pleading, and then these were dealt with as if stated in a regular series of affirmative pleadings in proper order. After answer filed, the plaintiff might amend his bill to anticipate defenses. Are you hearing them? Upon the new light given him by the defendant, and the defendant in turn was permitted to make a new answer to the amended bill. Why are we talking about complaints? Thus, the replication was actually sometimes incorporated in the bill along with the issuable facts, which consisted the equity of the bill, and which the plaintiff must prove to obtain the relief prayed for, and the defendant thereupon rejoined with new matter of defense. Now, just quickly, not taking up too much here, we talking about equity since we are, and we're seeing this bill thrown around a lot, which we are. Right? Let's look at what a bill in equity might look like. So instead of motions, right, instead of notice and demands, let's look and see what a bill in equity might look like. All right, a bill in equity for injunctive relief, equitable abatement, and the recognition of equitable substantive rights. Okay, and this would be, let's say Cameron James Wilson against the Honorable Tina Kotek in her official capacity as governor of the state of Oregon. Right, and we're pulling from the original equitable jurisdiction. That's what's being asserted here, right? Then you'd come through with your invocation of the equitable jurisdiction, bringing forth parties. I got my jurisdiction and venue in here. I got statement of equitable facts. And then I got the causes for equitable relief. First cause, the bill of equitable injunction, the bill to compel performance, right? The bill for equitable abatement, and then prayer for equitable relief. Okay, that's what a bill in equity would look like. There's quite a few of y'all in here. If you haven't hit the like button, y'all hit that thing, man. We got to get this algorithm back rolling up. Went too far down. I gotta go back up. Therefore, or thereafter, the plaintiff filed a replication as a mere matter of form to place the answer in issue. The bill in equity, therefore, consisted of three parts: the narrative, which contained a statement of the plaintiff's case for the relief; the charge, which anticipated and attempted to refute the defenses of the defendant; and the interrogative, which was to extract from him admissions under oath in his answer. It will be observed, therefore, that the bill and answer were generally framed so as to include the evidence by which each party sought to sustain his position or to defeat that of his adversary, as well as the legal arguments and conclusions which properly should have been presented in the briefs of counsel. On this very point of the theory of law and evidence, common law pleading and procedure was vastly superior to the civil law and to the procedure in equity. However, clearly substantive obligations and rights may be defined in any system of law. There can be no security or freedom for the individual when judicially investigated if competent evidence is rejected and incompetent evidence is admitted. Under the common law system of reducing controversies to a single issue of fact, the court could rule accurately upon the offers of evidence, admitting that which was proper and rejecting that which was improper. Whereas in equity, which adopted the civil law system of pleadings, permitting loose, detailed statements of both law and fact, as well as conclusions, the issue in dispute was placed in such doubt that the scope of the evidence was so broadened as frequently to permit the introduction of matter wholly foreign to the real controversy, which I just went through myself. Like, I just went through that myself. Like, you asking for something, but yet you bringing in all this evidence that doesn't even pertain to what you're asking for. Common law pleading, which was designed to frame a certain issue of fact for trial by 12 men, avoided this pitfall by indicating the character of and the limitations upon the evidence to be admitted. Its relation to code pleading. The relationship between the common law and the code systems as to the structure of pleadings has been largely obscured on the one hand by the procedural reformers who, as an incident of their objectives, have played down the advantages of the objective common law and played up the alleged superior qualities of the code procedure. And on the other hand, by the members of the teaching profession who have not had the ability or who have not taken the time and patience required to understand and appreciate pleading at common law. But speaking of this point, speaking of the point of relationship, it is clear that there are few rules regulating the substance of pleading under the modern codes and practice acts, which have not been directly borrowed from the common law or framed by analogy in the application of the same principle. In fact, the century following the adoption of the Code of Procedure of New York in 1848 has been one in which the common law rules have been read back into the apparently clear and simple provisions of the reformed procedure. The unadulterated truth being that such provisions had no legal content except as expounded against the appropriate common law procedural background. Code pleading is not, as many have assumed, a system having no relation to existing law. Common law pleading has not been abolished. It still survives as the basis of all legal investigation. It is, in fact, the direct linear ancestor or parent of code pleading, which literally springs from its join. At the best, the codification of pleading is only partial, leaving wide gaps in the system of remedial law to be filled by common law pleading, with its actual provisions interpretable only against the older system. Too much, G. Chill. It becomes clear, therefore, that one can only come to full apprehension of code pleading through the study of common law pleading. What is this professor saying? About to hurt them boys out there with that knowledge. Because then when you start bringing together the knowledge and the wisdom, when you know that you're a creation of the creator and that you have creator endowed rights that supersede all the statutory and the procedural codes that have been brought forth, you see, now we getting there. Hopefully this getting you somewhere. I know some of it's a little repetitive, but what it does is it ingrains that knowledge from the professors, the law scholars, right? To illustrate this point, let us take the common code provision that the complaint must state facts in, quote, plain and concise, unquote, language. We talking about rule of lenity here, huh? To one not trained in the common law, this means a statement of facts, as Charles O'Connor, the distinguished New York lawyer and pleader, observed, quote, just as any old woman in trouble for the first time would narrate her grievances and whipped into some semblance of order by use of a form book. To one trained in the common law, it would mean that the plaintiff, in order to state a cause of action, or the defendant, in order to state a defense, should state the ultimate facts, and not the evidence of facts and not conclusions of law, as pointed out in the leading New York case of Allen versus Patterson. What are you talking about? An affidavit? What are they talking about? An affidavit of fact? You know what I'm saying? Like, what are we talking about here? An affidavit of fact? What are you talking about? An affidavit of fact? Man, what all we got in this bad boy? What all we got in this bad boy? Let's see if I could. My boy been working in here on this one. Nope. Oh, John did a affidavit of fact, affirmation of facts. Oh, yeah. Affirmation of fact with verified claim in support of dismissal. Affirmation of capacity and standing. Statement of facts. Violation of constitutional rights, legal maxims and doctrines. Demand for dismissal through an affirmation of fact. Interesting. What is this, 22 at the top? It always goes down, I think. There it is. And not the evidence of facts and not conclusions of law, as pointed out in the leading New York case of Allen versus Patterson, excuse me. Bliss, in his famous work on code pleading, stated rules covering presumptions of fact, matters judicially noticed, anticipating defenses, and pleading evidence, conclusions of law, or immaterial or irrelevant matters. But in each instance, the source of such rule under the code is common law pleading. Each rule is in effect merely a restatement, in slightly different phraseology, of the rule as developed at common law. So likewise, as to the rules governing such matters as duplicity, certainty, consistency, directiveness, argumentativeness, allegations by way of recital, and alternative or hypothetical pleading. In fact, express statutory provisions aside, it may be said that if an attorney in fact or an attorney at law in a complaint under the code frames his allegation of fact in a manner to meet with the requirements of stating a cause of action or defense at common law, he need have no fear of being thrown out of court on demur because of some formal or substantive defect in his pleadings. Uh-oh. This is at footnote 63. Well, where's that footnote at? 66, 65, quoting Professor Cooley, 1898, shipment the aid of earlier systems. Indeed, the prophetic words of Professor Thomas M. Cooley seem as true today as when originally written, when, in referring to the relation of the new to the older system, he declared, quote, the works of common law pleading have not been superseded by the new codes which have been introduced. A careful study of these works is the very best preparation for the pleader, as well where a code is enforced as where the common law forms are still adhered to. Any exception which may have existed that the code was to banish technicality and substitute such simplicity that any man of common understanding was to be competent without legal training to present his case in due form of law has not been realized. Let's read that one more time. This is on that deep shit, bro. This is like what like judges be reading type shit. Like students type shit. You know what I'm saying? Let's read this again. Any exception which may have existed that the code was to banish technicality and substitute such simplicity of the common law that any man of common understanding was to be competent, just to know easily throughout without, again, legal training to present his case in due form of law has not been realized. When they out here saying they're going to hold you to the same standards and all that, that's not been, that's not what's up. The older system of common law is still there. It's still in effect. After a trial of the code system for many years, its friends must confess that there is something more than form in the old system of pleading, and that the attorney who has learned to state his case in a logical manner, or the pro se litigant, after the rules laid down by Stephen and Gold, is better prepared to draw a pleading that will stand the test on demur. The man who, without that training, undertakes to tell his story to the court as he might tell it to a neighbor, but who, never having accustomed himself to a strict and logical presentation of the precise facts which constitute the legal cause of action or the legal defense, is in danger of stating so much or so little, or of presenting the facts so inaccurately as to leave his rights in doubt on his own showing. Let the common law rules be mastered, and the work under the codes will prove easily and simple, and it will speedily be seen that no time has been lost or labor wasted in coming to the new practice by the old road. Toward the close of the 19th, okay, so now we're getting into the relation of the new federal rules of civil procedure. Okay, the codification of all of the acts and the bills and all the common law that had been put into place when they started bringing it all together, codifying everything. Toward the close of the 19th century, the American Bar Association conceded that legislative control of practice was highly inefficient, and that the Federal Conformity Act had produced no real conformity between the state and federal practice. In this situation, the association placed its influence behind a bill in Congress which provided for turning the federal rulemaking power over to the Supreme Court of the United States. After much agitation and much backing and filling, by the act of June 19th in 1934, the Congress gave the supreme power to prescribe by general rules for the district courts of the United States and for the courts of the District of Columbia in the forms of process, writs, pleadings, and motions, and the practice and procedure in civil actions at law. The rules as formulated under this act did not modify in any way the substantive rights of litigants. The act further provided that the court might unite the general rules prescribed by it for causes and equity with those in actions at law so as to secure one form of civil action and procedure for both. When they be saying all crimes are commercial, under one form of civil action and procedure for both, amen. Amen. There's our backing right there again. The right of trial by jury as at common law and declared by the 7th Amendment to the Constitution was preserved. Now, from the nature and character of the provisions of the Act of 1934, the rules of civil procedure as promulgated thereunder by the Supreme Court in 1938, it is clear that in scope and content, they were patterned after the provisions of our various state codes and practice acts, which, as previously indicated, were founded on the fundamental principles of common law procedure. There are, however, two chief differences. First, under the new system in the federal court, or maybe it's thief. I don't know. We'll see. First, under the new system in the federal courts and as adopted in several states, the control of pleading and practice by rule of court gives a flexibility in the application of the procedural law and in its adaptation to any need for change growing out of the new or unforeseen conditions as opposed to the older system of code pleading, which more or less placed procedure in a legislative straitjacket, leaving little room for development to meet changing social conditions. Second, under the codes, attempts to simplify and reduce the number of provisions regulating pleading did not meet with success. For example, the New York Civil Practice Act contains some 1,578 sections, supplemented by 301 rules of civil practice. In 1938, when a comparison was made between the new federal rules of civil procedure and the New York Code, it appeared that it took only 86 federal rules to cover substantially the area occupied by 1,100 of the 1,578 sections of the civil practice and 133 of the 301 New York rules of civil practice. And finally, it may be added that the spirit and tendency of the new system of procedure was represented by the federal rules of civil procedure and as regulated by the judges is in the direction of the common law, as is evidenced. To give but a single example, by the provision that all actions must be instituted through a clerk of court and by authority of a court, as at common law, as opposed to the code method of commencing an action by an individual or an attorney or litigant serving a summons and complaint upon the defendant. The status of common law pleading under the codes, acts, and federal rules of civil procedure. But even after a century of development under the codes, we still find that common law pleading survives in fact or in theory. On the basis of the degree of common law pleading which still prevails, the states fall into 5 groups: the common law states, the quasi-common law states, the code states, the rules of court states, civil law states. Okay, y'all following? Y'all digging on this? Y'all digging on this? Yeah, man. Hope y'all digging on this. If y'all digging on this, y'all let me know, man. You know, we out here trying to grind in the common law deep and get a deep understanding here. So I'm hoping y'all are digging this and y'all following along. If y'all do have any questions or you got anything to mention, lace them up in the chat, man. In the early part of the 19th century, the influence of Bentham began to be felt in America. By the New York Constitution of 1846, the Court of Chancery was abolished, and a new court having general jurisdiction over law and equity was created, and the legislature was directed to provide for the appointment of 3 commissioners. to revise, reform, simplify, and abridge the practice of and pleadings of the courts of record of the state. In response to this direction in the following year, the state legislature instructed the commissioners to provide for the abolition of the present forms of actions and pleadings in cases at common law, for a unified course of pleading in all cases, whether of legal or equitable cognizance, and for the abandonment of all Latin and other foreign tongues, so far as the same shall by them be deemed practicable, and of any form in proceeding not necessary to ascertain or preserve the rights of the parties. Under the directing genius of Davis Dudley Field, the commission formulated the report and reported a code which was passed on April 12, 1848, and became operative on July 1st, 1848, as the Code of Procedure, which was served as the source of most of our modern procedural reform. The greatest single achievement of the code, according to Professor Pomeroy, was the substitution of one form of action in place of the 11 common law forms of action. In addition, separate courts of law and equity were established in favor of what was hoped would turn out to be a blended system of procedure operating under a formless action to be known as a civil action, which was in the nature of an action on the case. The code also provided the pleadings should state the facts in plain and concise language, and that the more liberal provisions of equity procedure should govern joinder of parties, and provided for the rendition of judgments against one or more parties according to the particular interest of the parties involved. So within a quarter of a century after the adoption of the New York Code of Procedure in 1848, the code was adopted in 24 states. And according to Clark, some form of code procedure was in 1947 then in force in 29 states, 2 centuries, the District of Columbia, and in the federal courts. So even at this late date, it still remains true that the movement for reform, which took definite shape in 1848, has been only partially effective. Prior to the adoption of the new federal rules of civil procedure in 1938, the states were roughly lined in 4 groups, being classified as common law, quasi-common law, code, and civil law states. Code, and then civil law states. So after 1938, there may be added another group, the rules of court states. Perhaps a brief word concerning each type of jurisdiction may be helpful. The common law states. By the phrase common law states is meant those states in which the pleading is primary according to the common law rules, as unwritten law, or in the form of statutory enactment of the common law. Characteristic of the procedure of the states which fall into this group is the retention of the forms of actions and the rules of common law pleading, being under a court system that still calls for separate actions at law and suits in equity. Even so, the practice in these separate courts has from time to time been modified by local practice acts. The quasi-common law states. In these states, the formal distinction between law and equity has been continued, at least in theory, although in practice it has been weakened by statutes abolishing the distinctions between trespass and trespass on the case, or combining the forms of action in the 2 divisions of tort, a red contract. Usually in jurisdictions of character equitable defenses are permitted in law actions. Now moving into the code states. In the code states, originally largely patterned after the New York Code of Procedure, the system of pleading and practice are statutory, but based on a combination of the better features of the common law and equity procedural systems. The same rules apply to both law and equity cases, but it should be remembered that there is a far greater similarity in the essential principles of pleading at common law, in equity, and under the Reformed Code of Procedure than is generally realized. The essential elements of causes of action which must be pleaded are not changed by the codes, and the rules as to the manner of making allegations of the respective contentions of the parties still have much in common. It's a very important paragraph, y'all. Very important paragraph, y'all. Now, the rules of court states. These states are distinguished front the code states, whose pleading and practice is generally, if not entirely, evaluated by the legislature, in that their procedure is regulated by rules of court, usually framed by or under the authority of the court of highest jurisdiction, the Supreme Court. The advantage of regulating procedure by rule of court as opposed to legislative enactment is that of greater flexibility in making changes, as the social need therefore arises without the necessity of each time referring to the matter to a legislative body, which may be dilatory in taking action and is oftentimes influenced by political considerations. Since the promulgation of the new federal rules of civil procedure, a number of states have adopted the substance of the new rules in revising their procedure. Now let's speak on civil law states. In this group of systems of pleading were originally based upon the civil as opposed to the common law. Louisiana is a remaining state which began with a civil law background from which it has never fully escaped. Conclusion. Aside from the fact that after the lapse of over a century, almost a third of the several states of the United States were yet to accept the reform represented by the adoption of a code of civil procedure. Now have the codes been received. The object was a blend law and equity into a uniform mode of procedure. This was to be accomplished by abolition of the forms of action and the distinction between law and equity. A single form of action in nature of an action on the case was to be substituted in place of the common law forms of action and suits in equity. In codes, there were also provisions liberalizing the law controlling joinder of parties and joinder of causes of action, but unfortunately, many of the early codes omitted the later type of provision. Now, in some states, notably New York, the reformers under the Code of Procedure met with a cold reception. Thus, in Rubens versus Joel, Selden, in referring to the possibility of abolishing the distinctions between law and equity, declared, by what process can these two modes of relief be made incidental? Is it possible to abolish one or the other, or both? But it certainly is not possible to abolish the distinction between them. Another leading distinction between common law actions and suits in equity consists in their different modes of trial. The former to be tried by a jury, the latter by the court. Can the legislature abolish this distinction? They might, but for the restraints of the Constitution, abolish either kind of trial or reclassify the classes to which they apply, but they cannot make the trial by jury and a trial by the court the same thing. What such attitude has meant in practical terms is that a large part of the century following the adoption of the first codes has been spent by the judges in reading back into the code, provision by provision, the rules of common law. So according to Clark, the objections of the courts which have taken an unfriendly attitude toward the code reforms are 5 in number. 1, the necessity of forming clear and exact issues, both for the trial and also to support the judgment, and thus make the plea of res judica thereafter available to the parties. 2, inherent differences as to jurisdiction and venue, referring to the fact that certain actions must be brought in certain courts or at certain places. 3, inherent differences as to the application of certain statutes, such as the statutes of limitations, which were drawn along the lines of the old procedural divisions. 4, inherent differences in manner of or amount of relief to be granted, referring to the specific relief of equity as distinguished from the money damages ordinarily given at law, or to a possible variance in the amount of money damages recoverable, depending on the form of action chosen, or to particular remedies granted only in certain forms of action, such as the execution on the defendant's body. 5, inherent differences in manner of trial and of appellate review, referring to the constitutional right of trial by jury in law cases and to the different methods of appellate review in law and in equity cases. All these problems have, with a more liberal point of view on the part of the judges, been satisfactorily solved in other code states, according to Judge Clark. And it was his belief that in time the courts in New York would come around to the same view. But the very existence of the objections enumerated by Judge Clark 99 years after the adoption of the New York Code of Procedure in 1848, plus the fact that the numerous states are still without the circle of reform, is some slight indication of the tenacity of the common law. And when you add to this fact that the great bulk of the decisions under the codes have necessarily been made against the background of the common law, it becomes very clear why many distinguished judges cling to the thesis that the inherent and fundamental difference between actions at law and suits in equity cannot be ignored. A view which has found the support, at least, and of one distinguished teacher who stated, in referring to the abolition of the forms, that they are not archaic, accidental, artificial, or arbitrary, but in nature of things reasonable, if not intended in their essence necessary. Tough, bro. Tough, bro. This is that deep, right? Sometimes it's cool to get the forefront. You want to get the, yeah, we're reading this code and we're reading that code, but this is getting deep. And the deeper that we get, the more we comprehend, the more we know truly what we are as far as, again, creations of the creator. It's allowing us to understand the history, which is allowing us to tap back into what equity truly is, what common law really is. It's God's law, right? All right. So, says modern procedures under codes merely another step in the evolutionary development of common law. Okay. So, viewed in its proper historical perspective, any unbiased and well-informed student of legal history, generally, and of legal procedure, specifically, must observe that each new advance in our system of procedure was and is but another evolutionary step in the development of common law, and must acknowledge the fact that common law pleading, after the passage of some 7 or 8 centuries, still survives as the basis of our modern legal procedural systems as they exist in both the state and federal courts. Have the developments which have taken place since 1848 under the various codes of civil procedure and the practice acts of the several states, together with the federal rules of civil procedure, been revolutionary in character, wiping out the ancient landmarks of the common law and the procedural experience of the Anglo-Saxon race, extending over a period of 800 years? Or rather, have they been merely gradual steps in the evolutionary development of common law pleadings and practice? In the first or flexible stage of the development of common law, original writs issued out of chancery in great profusion, creating new rights and new law. It was during this period that the ancient proprietary and possessory real actions developed in great number. Altered the provisions of Oxford in 1258, the power of clerks in chancery was restricted. The real and mixed actions became so highly technical, difficult to manage, and lengthy in process that they became inflexible, and in consequence to the common law lost some of its inherent power of expansion. During this period of inflexibility, an effort to restore the authority of the clerks in chancery was made so that they might again create new rights by issuing new writs under Chapter 24 of the Statute of Westminster II in 1285. But the effort was too little and came too late, so that the residuary power of the King's Council operating through Chancery was invoked to supplement the common law, not necessarily because of the defects in the common law, but rather for reasons of state policy. As a result of the statute, perhaps, but more as a result of the growing social, economic, and mercantile needs of England, the modern personal common law actions, which to some extent ran parallel to the ancient proprietary and possessory actions, and which were generally emerging into greater prominence with the decline of these actions, were substituted in lieu of the old real actions which had predominated during the early development period of the common law. In the course of time, these modern forms of action, latest in point of growth, and the third state of development, were abolished in favor of a single formless form of action, under which remedies could be provided for the violation of private rights of most any character. With this in mind, let us swiftly glance back over the territory covered, and with almost 1,000 years perspective in mind, view the present status of common law pleading in practice as it stands in the light of modern reforms. From the reign of England of Edward I, 1272 to Geez, who knows? That's all jacked up. Okay, so no, to 1848, a period of 576 years elapsed, during which period in both England and the United States, legal procedure was governed by common law. When in England, the modern common law actions were substituted in the place of the old real actions, as is later observed. It was assumed that such an occurrence was merely a normal evolutionary development of the common law, based upon the change in the English social structure from one of a feudal to one of a commercial or industrial character. This chance became official or was procedurally recognized by the Real Property Limitations Act of 1833, which abolished the real and mixed actions. So when, therefore, in 1848, the New York Code of Procedure attempted to obliterate the distinctions between law and equity, to abolish the common law actions and to substitute in lieu thereof the modern single formless form of action, the world was witnessing not a revolutionary reform, which swept common law's system from its ancient moorings, but merely a third step in evolutionary development of common law procedure, like that which took place in the Roman system. Between 1848 and 1947, according to Clark, only 28 out of the 48 states followed New York in establishing code systems of procedure. And in those states which did follow New York's example, the intervening 100 years have been spent largely in reading back into the various code provisions, the appropriate intent of common law, and to acknowledge rule of the common law, the stubborn fact that common law by the Supreme Court of Judicature act pleading in practice, despite the passage of 1873. 81 now largely replaced the almost century still exists as the Supreme Court of Judicature consolidation basis of our modern legal procedure. Act of, okay, it's messing up again. I can't read that when it gets like that. Looks like it's messed up like this for a little bit. Let's see. England was anything other than evolutionary change in the common law, albeit the principles are applicable to them as to the long overdue simplest case. The flexibility. See, no, because it's mixing again here. See, finally should, believing that the sought and did place regulated and abandoned pleading, hence sacrifice to stating the elements of the Supreme Court, they remain the same as opposed to Congress. Some states in common law as a matter of substantive law in whole or impartially have emulated federal courts in regulating procedural by rule of court as opposed to the legislative fiat long and through survey of reform movements in both England and America in article theory of the common law principles of pleading still in effect declared. It's all over, y'all. I can't read it when it's like this. It's all messed up. Judgment of record, statements of claim, procedure in favor of the single, the defense verdicts, findings of fact, formless form of action, and the nature of the evidence introduced at trial, an action of trespass on the rights or on the case, or whether, like, see, where's whether? Where's the end of or whether? Where's the ER? You tell me. Or whether, see, oh, okay. We look at the situation today in the light of the court must be determinative of the legal sufficiency of our most recent procedure under the new federal rules of civil procedure. Or defense of the courts look only to the pleadings viewed in its proper historical perspective, which form a part of the record. For the court to be able to determine the legal sufficiency of any claim or defense, it must legally complete. I mean, it's, you see how it's mixed for me to read? I can't read it like this, y'all. I don't know what to say. I guess right here now I can see it's more lined out better as far as numerical. 10, 8. Oh, I have to read it like that. Oh, okay. I see what's going on. It's still hard to read no matter what. So 4. Just coming down here where it's easier, I guess. Hopefully. Facts to be true. 11, in determining the truth of a legally sufficient may not surprise his opponent by providing a different claim or defense. The courts look only to the, oh man, yeah, sheesh, that's bad. So we'll have to skip that part. Okay, so we're in chapter 2. How long are we in? About an hour. I'll go for a little bit longer. All right, y'all got to get them likes up though. All right, so let's see. Forms of action. I'm sorry that this document ended up being like this. Like, I can't really do much about that. Even when I go into the archive, like, I went into the archive and I found the same exact book, and the same exact book is formatted the same exact way. So whoever brought it forth into a PDF didn't scan each page. They did an OCR. So it's all messed up in its placement, and I'm sorry for that. So some sections are not going to be available for us to fully read because it's just hard for me to get through all that and waste time. And this is a big book. We'll get the substance of it. Don't worry. But we'll move into form of actions at this point. It has always seemed that this was to be put the cart before the horse, that no understandable effort to define what is meant by the phrase forms of action could be made except as against a somewhat detailed survey of the history of the common law forms of action, both ancient and modern. To present a definition to the student at a time when he has no appreciative background or conception of how the forms of action developed would appear to be an almost fruitless effort, but I think a lot of y'all here got it. In any event, it is respectfully submitted that the viewpoint of one who is seeking an understanding of the forms of action should be one in realization that the common law scheme of action was not framed, it grew. Origin of the common law forms of action. And the common law forms of action had their origin in the action and interaction which took place between the chancellor and the three royal courts, the king's bench, the executor, and the common pleas, whereby individual litigants applied to the chancery for original writs authorizing one of three courts to try a specific action. The multiplication of this process first produced the ancient real, mixed and personal common law actions, which later were superseded by the modern common law actions. How, then, did the formulary system of the common law develop the ancient and modern common law forms of action? And why is this knowledge of what was meant by the frame's forms of action essential to one who seeks to understand the law? Oh. The answer to these inquiries can only be discovered and understood against the background of the Norman conquest and the statesmanship of William the Conqueror, who, operating through the King's Council or Curia Regis, the King's Writ, the King's Inquest, and the doctrine of the King's Peace, did three things which left an undeniable imprint upon English legal history. In the first place, he organized the system of feudal tenure under which, in legal theory at least, the land was held in some form under the king, which explained why the king's courts were always keenly interested in any litigation, public or private, which affected the land. In the second case, he issued in 1007 what is now known as the Ordinance of William the Conqueror, which separated the ecclesiastical and common law courts. This development not only exercised a profound influence upon the procedural and substantive law of descent and distribution, wills and testaments, and probate and administration, but by reason of the fact that it left jurisdiction over freehold estates and the common law courts, it was largely responsible for the subsequent necessity of classifying the common law actions as real, mixed, and personal. And in the third, he established law and order through the creation of a centralized system of justice as an incident of which the common law forms of action were developed. The agencies by through which these things were done were, in the beginning, the king's private property. You see what I'm saying? It was the king's at this time. And they were not at first national institutions, nor were they a part of the regular machinery of administration. The nation was governed by the customary local law, which was administered by the local 100 shire and count courts, all the soldiers, right, of the king. Do as you're told, servant. Do as you're told, you oh, what is it? It starts with a P. You peon. You know, they was out here wild on these boys. It was ruthless, man. You get to work by the king's order, looking ass, you know? Like, they was ruthless out here, bro. Like, let's keep it real. I can see what's going on. Like the king got his shit going on, bro, and he's done hired people. Do you want the king's over here? Do you want to be a ruler? Do you want to have authority, or do you want to be authoritized? You know, it's been going back for ages. You dig what I'm talking about? There, the best brand of justice was not always available. Preserving this condition, William, in the process of political reorganization of the whole country, began creating a system of royal superior courts to which those not satisfied with the local courts might repair. See, because what was they doing? They literally had the boys. The king literally had the boys out there doing the, do you want more grapes? Do you want more bread? Do you want this whore? Then get out there and do what I say. You know, like I could see it, bro. I could see it, bro. I could tap into the source and see what was happening, bro. So that's what happened. Okay. And it was through the operation of these new courts under William the Conqueror and all the rest that follow that the centralization of justice was achieved. An action could be instituted in each of the three superior royal courts, a king's bench, executor, and a common pleas, each presided over by 4 judges. Okay, getting your history. Okay. Jurisdiction was distributed as follows. The court of the king's bench exercised control over crimes, torts akin to crimes, and other business pertaining to the crown. Matters of revenue accepted. The court of executor handled cases relating to taxation and revenue, while the court of common pleas dealt with the ordinary civil suits between subject and subject, known as communia placita, in the three-cornered struggle for jurisdiction. The king's bench, by resort of a fictitious allegation of trespass, under which control of the defendant could be secured by an arrest, expanded its jurisdiction at the expense of the other 2 courts in a manner so as to include all personal actions. By a similar process of usurpation, the court of executor also came to exercise jurisdiction over personal actions, but the jurisdiction of neither court extended to the cognizance of the real and mixed actions. In the meantime, the Court of Common Pleas continued to exercise its original jurisdiction, which included the authority to entertain all actions between the subjects of king, real, mixed, or personal, such as the ancient propriety writs of right, the possessory assizes, writs of entry, and writs of entry of forcible detainer, or such modern actions as account, covenant, debt, or indenture, then to existence and in time over those personal actions of later vintage. In the king's bench and common pleas, an action could be commenced either by an original writ or by bill, and an executor by bills only. The former method of commencing an action, according to Stephen, is the regular and ancient one, and the latter is in the nature of an exception to it. The proceeding by original writ consequently claims first notice. Now, claims first notice. So on this next part 3, tomorrow, again, same time, 7:30 in the morning for me, PST, we're going to be going over the proceeding by no, we're not. Tomorrow's Saturday. Today's Friday. No, we're not. Tomorrow's going to be Operation Wise Dome. You know what? I might still do it. I might still do this. And then we'll do Operation Wise Dome at 8:30. Yeah, that's fine with me. I'll do it like that. So we're still going to do part 3 of the handbook of the common law pleading. We're going to be moving into part 3, which is going to be moving into the original writ. You're enjoying this because what it's doing is it's giving a foundational basis of common law, how common law is still in place today, how it's the foundation of everything. We're getting our history into it, which I love history, right? Because then I can understand to show where authority is always meant to be. Just like you can utilize it with statutes, legislature through the whole act rule, right? Bringing it all the way back to the intent of the creation of the legislature in itself without all the enactments that changed things up from its originality, in conjunction with the rule of lenity to make sure that we're not going outside of the bounds, because most of these statutes should be relating back to common law with an intent, and that intent must be matched also with the act in and of itself, right? So what I'm understanding it is that, again, the actus rea and the mens rea must be both in place, and they must both be there for there to be a crime. If the act was an act without the intent of therefore being a crime, there is no crime because both must come forth together. And I think now it's like when the courts come in and they're establishing jurisdiction and they're establishing probable cause, what's happening is that probable cause, it's only a preponderance level, right? It's a preponderance level, meaning that all they have to do is tip the scale. Probable cause is very low bar and threshold to make. So they say, hey, well, this is what they say. This is the claim. Let's move it forward into the next stage, start going into the facts and start going into conclusions of law. When you get into factual findings and conclusions of law, that's where, again, like this handbook is telling us, is where we start to wind down, we start to shave everything out. Right now, you got a big ass block, like you're a sculptor. Let's just say you're a sculptor. You're sculpting a big ass bear or something like that, right? But you do very great on the detail. It's very blocky at first. You got to chop her down. You got to get her at least formed before you start molding and getting into greater detail to make a very concise image of what are the facts that we're looking at. Let's get away with everything that's hearsay. Let's get away with everything that's a constitutional violation. Let's get away with everything that is poisonous fruits from this tree, right? Let's wipe away everything that cannot be applied. Then we move forward into, again, findings of facts and conclusions of law. Or that is the process in which we get down to the shaving of everything to actually go through jury trial. When people come through with all of this, you file this and you file that, and if you got this silver bullet and all this money on the background, bro, you understand how many people died for you to secure and have your freedoms and your rights, to be able to stand on your rights and utilize this process and not just get judged and killed like we just talking about when it comes to the King's way. Kill that peon. I don't want to see him anymore. Yes, Josiah. They just kill him. Like, we got a system here that hundreds and millions of people died for, bro, for you to stand on, for you to learn, for you to encompass. Not to just say, oh, I filed this piece of paper and now I don't have to abide by anything no more. Like, you really think that's how it goes? And if it does go like that, why don't these people show any proof? They do a lot of talking, but I don't see no proof. I don't see no proof. I see our own people in Wise Dome doing their own stuff and literally going into the courts and doing their own talks, speeches, getting their own cases dropped. Right? And that becomes from empowering themselves on knowing that they have creator endowed rights and that there's rights and processes, privileges that are guaranteed to you always at any given time that the opposing party, which is the state and or the corporation, is placing against you. And if they can't combat that or beat that, they're in a real strong, you have so much power. You just have to invoke your power. And that's what it comes down to. So as we move through this this common law handbook, wrote by several different professors, compiled by several different professors, 735 pages. I hope we continue to empower ourselves with knowing. And as we're getting historical, we're going to get into more greater details on this thing. This thing is amazing. And we'll work on it day by day. I love y'all. I want y'all to remember that I am you, we are us, and we are all a part of this great I am. I got to get to it, man. I got to get to it. If y'all need me for anything, again, you can bio.site/CJW in the chat right now. It's there in the description down below, and there will be a pinned comment as well. I am you, we are us. We're all a part of the great I am. I love y'all. I'll see y'all tomorrow.